where he had an implant earlier this year. The implant is in his groin area.
My penis area.
One of them has dislodged and is now in his testicle.
I need it removed, Your Honor. It's very painful.
Well, I'm not going to remove it for you, so you should tell the jail that you need medical assistance. And this is People v. Brian Van Oler. It is filed 24-93340FC up for docket call. We've got Mr. Van Oler videoing in from the Presqu'île jail, Mr. McLennan for the people, and Mr. Vogler for the defense. And we're here for a docket call and also a motion for bond reduction. So, Mr. Vogler, I guess, where are we at on the underlying case itself?
Your Honor, I just looking at the court's order, I guess we're treating this as a pretrial conference. So right now, in terms of our possibility of filing a motion, I guess, we are looking at the affidavit that was filed to acquire the first search warrant here. Haven't come to a final conclusion yet as to whether or not we're going to challenge that. But that would be most likely motion if we were to file one here.
All right, and appropriate for a second docket call and evidentiary motion cutoff February 3rd at 10:20.
That would be fine.
Now, as to your motion for bond reduction, go ahead.
Your Honor, the last time we were here for the arraignment, I made a motion, really denied it without prejudice. And what I took away from that hearing, the court wanted to become a little bit more familiar with the kidnapping charge here. And so I tried to lay out at least what I believe to be the merits of that particular charge. This bond was initially set based on the kidnapping charge and a fourth habitual offender notice that had carried a 25-year mandatory minimum sentence with it. That habitual notice is now down to a third. But I think more importantly is what the quality of that kidnapping case. It's just not, to me, I think it tells you something that the plea offer, we waived prelim based on an offer that essentially, will and would dismiss the kidnapping charge if in fact we go ahead with that plea. So I look at that kidnapping charge, and I think that's one of the things you want to look at in terms of setting bond. What's the potential there for a conviction? And I would rate that extremely low.
Right, and I'll grant you that you read a charge of kidnapping and many possibilities are brought to the mind. And the facts in the affidavit are not exactly those possibilities. I'm not saying that the facts don't fit the charge, but that the facts of that charge are not necessarily the facts one thinks of when you hear the word kidnapping.
No, it's postured as a hostage shield type of kidnapping. Neither one of those, I can't see how they possibly exist. And this stuff is all captured on body cam from two different officers. One, it's from me to your court officer away through a partially open window. It's in all the time that we're talking about here. The police had in their back pocket a search warrant. They could have just entered the house at any point in time. Nobody had any guns drawn. There was no demands made in terms of I'll release this child if you do this or that. I mean, none of that existed.
Thank you. Can I see the file? Mr. McLennan, people's position.
Your Honor, the people would oppose a reduction in bond. I will grant that maybe this isn't all the things one would normally think of with it. However, when you do look at the police report, it was a really concerning situation. Mr. Van Oler did refuse the lawful commands of the officers to turn DHHS. And after the child was turned over, the police report indicates that he ran towards the bedroom, where it was later found there were weapons. As he was doing that, he was tased and taken to the ground where two other officers had to assist in detaining him. So I do think that the underlying facts are still, we would oppose a reduction in bond. The court does feel it reasonable to reduce bond. We would ask that it be minimal.
Thank you. Well, the bond was set in the district court at $500,000 cash or surety to the full amount with several conditions. Those conditions, in addition to the standard conditions, included no contact, no use, possession, controlled substances, even requiring a GPS tether before being released from jail, calling the bond line, providing testing, and not having any weapons or firearms. Those are all, I think, given the facts, reasonable conditions. I'd continue those conditions. I do think a couple factors do warrant a reduction in the amount of the bond. The conditions are what's there to really secure public safety. I think there are a couple factors that warrant a reduction are, as Mr. Vogler outlined, the dismissal of the habitual fourth offender notice, which had been mistakenly filed, which had artificially increased a mandatory minimum sentence, which is not applicable in this case. And secondly, as I read the affidavit that was attached to your motion, Mr. Vogler, it did appear that this was, I certainly agree with the prosecuting attorney that these facts, if they're proven at trial, are concerning facts. But this was on a spectrum of behavior more along the lines of not cooperating with an exchange rather than a child abduction sort of situation or hostage demands or things like that. So I do think a reduction in bond is appropriate. I'm going to grant the motion, reduce the bond to $25,000 cash or surety to the full amount with the same conditions.
Excuse me, Your Honor, may I speak?
Well, you may want to consider talking to Mr. Vogler before you do.
Mr. Vogler, can we talk about the medical issue that I have?
Yeah, I think that's what he just wants to bring up, that he's had a situation where he had an implant earlier this year. The implant is in his groin area, and that which consisted of a couple of balloons being put into
My penis area.
One of them has dislodged and is now in his testicle, and that's something that he feels that he needs to.
I need it removed, Your Honor. It's very painful.
Well, I'm not going to remove it for you, so you should tell the jail that you need medical assistance, and they will care as they do.
Your Honor,
they house people every day of every year, and they
Your Honor,
as are needed. So go that
Your
route.
Honor, I have been asking for medical help outside of here, and they keep refusing me. They tell me when I get out, I can take care of it. That's what I've been told since I've been in here.
Okay, well, that's what you got a lawyer for as well. I'm not going to do anything for you just on a verbal. You telling me, one inmate from the jail telling me they've got something going on, that doesn't give me the kind of information or notice to the prosecutor that allows us to do a darn thing about it today. The jail will provide for your medical needs. They do it for all the inmates that they have every day of every year. So I have no way of knowing whether what you're telling me is so or is exaggerated or whatnot. So get some documentation about that. And if the jail is not, then you've got the court's attention in the proper way instead of in this way. So I have reduced your bond. That is probably something you'll be able to post and take care of on your own.
How much is the bond, Your Honor?
$25,000 cash or surety to the full amount with the same conditions that were previously assessed. Next court date is February 3rd at 10:20 a.m. All right, we'll see you then.
Thank you, sir.
Thank you, Your Honor.
Thank you.